Good afternoon, everyone, and welcome to today's session of Trinity Talks. My name is Rinku Badoria. I'm a partner in the London office of Trinity International, and I'll be your moderator today. So today we will be discussing OFAC, an introduction to US sanction laws. The presentation will be delivered by my colleagues, partner Tom Eldert and counsel Eric Philippink, who are both based in our Washington, DC office. In terms of format, the presentation will last for around 30 minutes and we'll have 5 to 10 minutes to answer questions. On that note, please do feel free to use your Q&A function on the screen to submit questions, and we will get through as many as possible at the end of the session. So without further ado, I will now pass you over to Tom to start the presentation.
Great. Thank you, Rinku, and welcome everybody. So we're here today to talk about US sanctions. This is obviously a broad area and we could spend 3 days on it. In terms of getting into the details, it's a fairly complex area. For purposes of today's talk, we're trying to focus on the practical aspect of it, and particularly for non-US entities that often see clauses in their contracts that say that they that will provide either a representation warranty or affirmative or negative covenants that they'll comply with US sanctions laws. How do you decide whether or not that's something you can actually agree to? So in terms of the outline for the presentation, we'll start with a general overview. We'll then go into a bit of the details on the OFAC sanctions. We'll talk about applicability and particularly extraterritorial jurisdiction over non-US entities, risk assessment and management, and drafting, and other practical tips. Next slide. So broadly speaking, the US sanctions, export, and similar type of programs are actually quite numerous. They're under a variety of laws and under the jurisdiction of multiple agencies within the US government. The sanctions program, which is trade embargoes and general prohibitions on dealing with specific individuals, is administered by OFAC, which is the Office of Foreign Assets Control under the US Treasury Department. ITAR, which is governs the export of military equipment or products, is governed by the State Department. For the export of civilian or dual-use products, that's governed by the Bureau of Industry and Security under the Commerce Department. Anti-money laundering and Patriot Act regulations are conducted by the Treasury Department. Foreign Corrupt Practices Act are governed by the SEC and the Department of Justice. Anti-boycott is worth knowing about only if you're dealing with US entities, which in principle prevents compliance by US persons with boycotts of specified countries. In practice, this basically means US companies cannot comply with the Arab League boycott of Israel. I don't believe it's been applied to any other country in practice. There are other programs and sanction-like regulations by the Defense Department, Homeland Security, and others. So the main takeaway of this is it's a big landscape, but we'll get into how you can navigate it as a practical matter. Next slide. So focusing specifically on sanctions, sanctions are administered by the Office of Foreign Assets Control under the Treasury Department. It is tasked with the administration and enforcement of economic and trade sanctions, and this is based on a broad mandate with respect to US foreign policy and national security goals. In practice, it tends to be targeted to areas like terrorism, drug trafficking, human trafficking, and weapons proliferation. Next slide. So historically, sanctions have been broken down into 2 different categories. There's comprehensive or jurisdictional sanctions. These are basically trade embargoes against a specific country. So in the beginning of the US sanctions program, particularly during the Cold War, this was broadly applied to prevent trading with Soviet and similar type of countries, and for until recently, Iran, North Korea, countries like that fell into it. The second basket is non-comprehensive, and that's based on specified targeted individuals or entities, and these are people involved in terrorism, drug trafficking, human rights violations, issues like that. With respect to the comprehensive embargoes, currently it's, other than North Korea and Syria, it's a bit of a gray area. North Korea and Syria, you're basically prohibited from dealing with if you're a US entity. Venezuela, for the most part, you are, but that one's a little bit in between the targeted or non-comprehensive area. Iran, until the Obama administration, was heavily embargoed. As part of the nuclear negotiations, Obama eased the sanctions on Iran, but the Trump administration has withdrawn from that treaty and has reimposed certain sanctions. So I put a question mark on this because it's heading in the direction of going back towards being a more comprehensive embargo than it was a couple of years ago. Even if there's a jurisdiction that is subject to sanctions, there are certain exceptions, and these fall under the form of general and specific licenses. So with Iran, back when it was more or less fully embargoed, for example, there were general licenses that allowed the provision of food and humanitarian assistance, education, and internet services. And the same was true for Cuba as well. Next slide. So we won't go into details on this, but this is a list of all the different types of sanctions that are currently in effect as of yesterday. As mentioned earlier, there's a number of acts of Congress and executive orders that govern all of these. So the main takeaway is that there's no one specific sanctions rule. There's multiple sanctions rules, and they're different for each country, for each type of area. For example, rough diamond trades or blood diamond. And both the penalties, the application vary from the program to program. And so it's quite complicated, particularly for a non-US entity, to know exactly who you have to deal with. And so that's the bad news. But the good news is on the next slide. So as a practical matter, particularly given that the sanctions programs are literally changing day by day. In fact, the list that was on the previous slide, a number of those have been updated in the last month. So that would obviously make it extremely difficult to keep track of all this, particularly for an entity that's not actively involved with US activities. The good news is, as I mentioned, because there's been a shift towards more targeted sanctions, OFAC maintains on their website 2 lists that can be used to check whether or not you're dealing with a potentially sanctioned entity or person. The first is the specially designated nationals list. These are individuals or entities that are specifically named by OFAC under executive orders, under acts of Congress, as subject to sanctions. And it's a very easily searched PDF. So you can just simply click on it, run a search, and you can find in whether or not you have a hit in a matter of seconds. The one bit of caution on that is there are a number of names, particularly Arabic and Spanish names, where they're quite common. So you may get a hit. That doesn't necessarily mean that the person is sanctioned. You just have to do additional diligence. In fact, my wife's name was on it at one point, but it wasn't her. The second is the consolidated sanctions list, which is relatively new. This is kind of the secret list of entities that haven't necessarily been published in the registrar as subject to sanctions, but are blocked under both OFAC and other US government program. So this is actually a useful addition as a secondary background check. Next slide, please. So penalties. As a general matter across the programs, there's OFAC does apply strict liability. The fact that you didn't know you're dealing with a terrorist isn't a defense by itself. The specific penalties vary by program. As we noted earlier, there's a lot of different programs, and the penalties actually are different for each one. But in each case, they tend to be potentially quite severe. They can range up to $20 million per violation, and for individuals can be up to 30 years in jail time. So again, that's bad news. The good news is OFAC's not really looking to punish inadvertent violations of the sanctions program. What they really want is compliance with it. And so in that respect, they do encourage mitigation, and they'll take that into account if there is a violation. And the main things you can do to mitigate a potential violation is self-reporting. And I can't emphasize this enough. If you think that you may have violated the sanctions program, I mean, first talk to a lawyer, but second, report it to OFAC. If they find out about it, the punishment by themselves, the punishment's can be much more severe than if you go to them, say, I'm sorry, and tell them about it. The second aspect that they look at, and we'll get into this at the end in practical tips as well, is have a compliance program in place. It doesn't necessarily have to be US focused if you're not primarily dealing with the United States. But there's obviously EU sanctions, there's UN sanctions, there's Japanese sanctions. So you should have some sort of formal compliance program in place that's documented that you can then show them if there is a violation that you were trying to comply and this just slipped through the cracks. And with that, I'll pass it over to Eric.
Thank you very much, Tom. So I'm going to start today just by saying a few words about the applicability of sanctions under OFAC. So as Tom said, OFAC prohibits trade in financial transactions or other types of dealings involving US persons, unless those transactions are either authorized by OFAC, and Tom mentioned securing an OFAC license, or if those sanctions, or if those actions or those transactions are expressly exempted by statute, such as in the case of humanitarian exemptions that may apply. Now, what constitutes a US person is quite broad, and it has extraterritorial applicability. US persons includes all US citizens and permanent resident aliens, regardless of where they are located in the world. This means all persons and entities physically within the United States as well. And it also means all US incorporated entities and their foreign branches. In certain cases, it can also include foreign subsidiaries that are owned or controlled by US companies, which also must comply with the sanctions. So for a non-US business operating outside of the United States, this could mean that any of its shareholders, directors, employees who are US citizens, based again anywhere in the world, that they could fall under sanctions prohibitions. Now, if this is the case, then such persons would need to be kept segregated from having any involvement in a potentially sanctioned transaction. And you can do this through having separate email streams, making sure that such persons do not have access to files, and in addition, not taking any part in the decision-making affecting the transaction. Now, although this means that non-US companies outside the US can still conduct business with OFAC sanctioned targets or in OFAC sanctioned territories, OFAC's extraterritorial enforcement jurisdiction can also arise through the use of US dollar payments. And why? This is because these US dollar payments are typically routed through the US financial system. And we have seen recent examples of these over the past several years. So for example, we've seen OFAC penalize non-US banks for processing US dollar transactions involving sanctioned countries such as Iran. And we have also seen OFAC penalize a non-US company that was not a financial institution, but this company made payments through a non-US based bank account, so a bank account outside the US, to third-party vendors who then in turn provided goods and services to Iran. So the jurisdiction in this case arose for OFAC because the transaction involved the use of US dollars for making the payments. So all of this said, when contemplating a transaction, a lender will need to consider certain risks, meaning potential civil or criminal liability if they violate US sanctions. And again, as Tom pointed out, there is strict liability. Either you have broken the law, and if you have, then you are strictly liable for that. So OFAC can apply civil or criminal penalties to you. There is also commercial or credit risk. So for example, in a sanctioned transaction, a borrower that may fall under sanctions or become subject to sanctions may not be able to repay a loan. And even worse, if there are blocking sanctions, the loan itself and the proceeds of the loan may become blocked property, and any payments put into a blocked account and out of reach of the lender. And then of course there is your reputational risk. So for a lender to consider a transaction, even if the transaction may be technically legal, the lender may consider that they would suffer any damage to its reputation as a result of being associated with a potentially suspicious transaction, even if one is technically legal, but there is some aspect to it that could be falling under the OFAC sanctions. So I will pause here just for a moment to mention the de minimis rule. For the most part, OFAC does not prohibit entirely transactions where a borrower could conduct some small part of its business with sanctions targets. US lenders can still make such loans, provided that the business involving those sanction targets is de minimis. Now, what does de minimis mean? Unfortunately, there's no real bright line rule that we can look to, but broadly speaking, OFAC, again, based on practice, OFAC allows up to 10% of assets, revenues, profits may be deemed acceptable, depending on the circumstances. And of course, it's depending on circumstances. So OFAC could decide in a given case that a lower threshold will apply, and 10% is more than de minimis. So truthfully, even $1 given to a sanctions target, and even if that is given indirectly, could be considered a violation in which strict liability would apply. So what can a lender do to protect itself in a loan agreement in order to minimize the risks? As we said, the sanctions regime is an ever-changing landscape. So there are certain provisions that lenders can put into their loan agreements in order to mitigate the risks coming from sanctions. So next slide, please. We thought as part of this presentation that we would put together some guidance based on the LSTA recommendations for sanctions-related clauses that you would find in loan agreements. And for these, we will touch upon a recommended language for representations and warranties, for your affirmative covenants, your negative covenants, and then we will mention events of default. So let's begin by looking at the terms that we would see in representations and warranties. So if we can go to the next slide, please. Essentially, a borrower will want, essentially a lender will want the borrower to state that neither it nor any member of its group is the target of any sanctions or is located in a sanctioned country. So in terms of drafting the representation and warranty, the key terms that we would look for is that, first of all, it will refer to the borrower and all of its subsidiaries. And it will also make reference to its directors, officers, employees, agents, and affiliates to ensure that everyone is encompassed in this representation and warranty. And then it will state that these persons are not themselves, nor are they owned by, nor are they controlled by any persons who are either one, subject to any sanctions, or two, located, organized, or resident in any country or territory that is subject to any sanctions. Now, often we see representations and warranties that leave out some of these elements, and so this is why I wanted to stress that we are looking at both being subject to sanctions and being located, organized, or resident in any country or territory that is subject to any sanctions. So for example, we often will see representations that simply say that the that the borrower and its subsidiaries and its directors, etc., are not listed on OFAC's SDN list. Well, quite frankly, this is a defective clause because, as Tom noted, first of all, there are other sanctions lists overseen by other departments within the US government. And in addition, it's defective because it doesn't refer to any country or territory. Sanctions can be applied territorially as well. So just by referring to somebody as not being on a sanctions list will not actually capture whether or not they are doing business or are organized in a sanctioned territory or country. Next slide, please. So now let's take a look at the key terms for an affirmative covenant or a positive undertaking. In general, you will have a compliance with laws covenant that will already cover any requirement that a borrower will have to comply with any applicable sanctions related laws. So in order to avoid being duplicative, it is more helpful for a lender to include an affirmative covenant that requires the borrower to have in place policies and procedures that are designed to ensure compliance by the directors, employees, agents with any applicable sanctions. Now, sometimes you will see this formulation that we've provided here also in the form of a representation and warranty. Now, this is okay, and it is an okay representation to have so long as it is along with the other one that we discussed. But a lender will really want to see that this compliance requirement is going to be going forward as well. And for this reason, this is why it's included as an affirmative covenant, so that the borrower will comply and make sure that it has in place such programs on a going forward basis. And in fact, this covenant comports with OFAC's own guidance that it released back in May of 2019, so a little more than a year ago, where it provides guidance for sanctions compliance programs. Let's go on to the next slide, please. So in speaking of negative covenants, your negative covenant will focus on prohibiting the use of the loan proceeds in a way that would violate any applicable sanctions. The key terms here are that the negative covenant will require that the borrower not directly or indirectly, importantly, you must include indirectly because it could be through the use of third parties, that the borrower cannot use the proceeds of the loan to fund any activities or business of or with a person or in a country or territory subject to any sanctions, or in a manner that would result in a violation of any sanctions by any person. And here by person, we can also include references to the administrative agents, the issuing bank, the lenders, underwriters, advisors, etc. So you will note here that once again, the recommended terms refer both to activities or business of or with a person or use in a country or territory that is subject to any sanctions. So here we have prohibitions dealing with the person, so a person on the OFAC SDN list, as well as the proceeds being used in any territory subject to any sanctions. And we point this out because we need to be as complete as possible. So next slide, please. What does this mean? Well, the reason for including the prohibition on the use of proceeds as a negative covenant, this will trigger an immediate event of default. Breaches of affirmative covenants, by contrast, will often allow for notice periods and grace periods before an event of default is declared. But as there is strict liability for any sanctions violations, the rationale is clear as to why this is an immediate event of default through a negative covenant. Though I will say that in DFI lending, we do see that any covenants, affirmative or negative, having to do with sanctions will really trigger an immediate event of default without the allowance for any grace periods or remedies to be made. And this will allow the lender to accelerate the loan. So at this point, I also want to bring up another topic, since we referred to accelerating the loan. And here I thought that it would be convenient to mention a related issue involving the illegality clause that you will find in loan agreements. And your illegality clause will typically say something like, if it becomes unlawful in a jurisdiction for a lender to perform any of its obligations under this agreement, or to fund or maintain its participation in any loan, this is how the clause starts, this will then allow for the affected lender to cancel its commitment and accelerate its part of the loan. And so the reason we tied this into the event of default is that with the acceleration of the loan under the illegality clause, what we said today in terms of the extraterritorial reach of US sanctions laws and how frequently and rapidly the sanctions can change depending on international political circumstances, it is entirely possible that over the course of the life of the loan, it may become illegal for a US lender to maintain that loan. And so if there are, in fact, multiple lenders, the loan might not be illegal for all of them. And so what does this then say for the overall facility? Can the borrower find an adequate replacement for the US lender that has to drop out? For reputational risk reasons that we mentioned earlier, will other lenders want to maintain the loan, even if it is not illegal for them? So from this clause, a lot of intercreditor discussions will ensue once it is triggered. Now, depending on how sanctions are applied, existing loans could be actually subject to a grandfather clause, so as to not disrupt the status quo. So existing loans could continue, but any new loans might not be able to be made in a sanctioned jurisdiction or to a sanctioned person. But in some cases, we see these days that there are no grandfather clauses and existing loans would definitely need to be wound down. And here in this case, I'm thinking recently in the past few months that we saw the removal of any grandfather clauses in relation to US sanctions on Russian energy pipeline involvement. And so highlighting risks such as this, I'm going to hand it back over to Tom, who will give us some final comments, wrap things up, and provide some additional tips for consideration.
Tom, I think you're on mute.
We'll try that again. Thank you, Eric. Right, so we just wanted to leave you with a couple simple practical tips to help stay out of trouble, in addition to the drafting comments that Eric just mentioned. The first is have a compliance program. This should be something that's documented. It should have a designated point person who's tasked with keeping abreast of sanctions programs generally. As mentioned earlier, this doesn't necessarily have to be US specific. If you have minimal involvement with the US, that's fine. But whatever jurisdiction you're in, it's generally a good practice to have. As I mentioned, there's sanctions programs from pretty much every country. And in most cases, this is a mitigating factor, even if you do inadvertently violate sanctions. And that's certainly true for OFAC. The second is, with respect to OFAC and US sanctions specifically, conduct a simple transaction risk assessment at the beginning. And the first question is, are US persons or the US financial system involved? If the answer is no, you can probably safely stop there. The key is really the second part. You'll obviously know if there's US persons involved, but the financial system is pretty broad in terms of how OFAC has interpreted it, particularly with respect to Iranian sanctions. So kind of a good rule of thumb is if there's dollars involved in the transaction, there's a good chance that the US financial system is involved and US sanctions could be relevant for that transaction. Assuming one of those two is true, the next step is look at the reputation and risk of your investors and counterparties. If you're dealing with Siemens out of Germany, you probably can stop there. If you're dealing with a developer you just met on the airplane out of another jurisdiction, then that's when you're going to want to put a little more effort into researching the background. And in particular, I think it's a rational approach to base it on where these counterparties are located or resident in, and looking at it from OFAC's perspective, not necessarily a comment on the countries themselves, but that would specifically include places like Iran, North Korea, but no one's dealing with them, Syria, broadly the Middle East, frankly, and Latin American jurisdictions that are known for drug trafficking, as well as the Golden Triangle in Asia. So those are places where you might want to do a little more extra research on background. Third, if you do have US employees or shareholders, and you're involved in transactions that may be perfectly legal under the laws that you're governed by, but would be potentially problematic under the US sanctions program, isolate. And this is particularly true for managers or shareholders that have decision-making capabilities. We've had a number of clients that were European companies that were doing business in Iran that was perfectly legitimate under their laws, but had either US employees or US shareholders that needed to be isolated from the decision-making. So they can't vote on a budget, for example, that would include financing a project in Iran that would be illegal under OFAC sanctions. And finally, if in doubt, talk to a lawyer. The next step after that would probably be, if there is a potential issue, reporting it to OFAC, and that would mitigate any penalties. So we hope that's helpful. If anybody has questions, we're happy to field them now, and also feel free to reach out to us directly at any time in the future. Thank you.
Thanks, Tom and Eric. We have had a couple of questions. So the first question we have is, how much room does the borrower have to negotiate the individual terms of the sanctions clauses? Eric, if I could pass that question on to you.
Certainly. Thank you very much. Now, admittedly, the recommendations and the practical tips that we gave on the drafting were really lender focused. So how could the lender minimize the risk through the terms of its loan agreement? And we didn't really touch on how the borrower can negotiate that. And quite frankly, borrowers do ask this question: how much can they push back? And unfortunately, we have to say they can push back very little. So in particular, if the borrower is negotiating with a DFI or a multilateral lender, then basically you really just have to accept the provisions that are written, because the persons within those institutions who have the authority to change are not going to change the provisions because there are a number of reasons, not least of which being the precedent that would set in changing it. And those provisions have been vetted and reviewed for a reason, to ensure that the reputational risk of the governments who are acting as the lenders do not get caught up in any sanctions violations. Now, for commercial banks, though, on the other hand, a borrower might have a bit more success. There's somewhat more leeway in negotiating with commercial banks, but to be honest, commercial banks are also on a heightened state of alert over sanctions and anti-money laundering issues. And so, given recent actions taken by OFAC in the past several years, commercial banks also are really unwilling to relax how tight these clauses may be in their agreements. Now, that said, there are a few issues that a borrower can legitimately try to negotiate. So, for example, a lot will really depend on the corporate structure of the borrower. And so you will recall when I talked about the representations and warranties, I said that it should include the borrower and all of its subsidiaries. There's also reference there usually to affiliates. So, for example, a borrower might persuasively argue that in a very large corporate structure with far-flung operations around the world, that the borrower cannot possibly rep to what any of its affiliates are doing in countries in which it really has no day-to-day connection whatsoever. I have even seen a borrower successfully negotiate as to its subsidiaries, which you might think that the borrower should know what its subsidiaries will do. But in an odd quirk of the management structure, some of the subsidiaries were completely removed from the borrower's own management structure, and they were managed separately. And so in that case, the borrower was able to restrict the rep and warranty to just itself and not some of its subsidiaries. A borrower could also try to introduce some knowledge qualifiers, such as in the case of the negative covenant, the use of proceeds, if you will recall. We said that you want to say that the borrower cannot directly or indirectly use the proceeds. Here, a borrower might be able to negotiate putting in a knowledge qualifier on indirectly, so they might not knowingly indirectly use the proceeds of the loan. This could be an area where you could have some success. For example, if there's an on-lending situation, you show that you have in the end user loan agreements certain provisions, and then if for some reason there's a violation, it was not you did not knowingly know how the indirect use of the proceeds of the loan occurred. That could be another area for a borrower to pursue. But basically, the more that a borrower pushes, and we just have to be honest about it, it sends up red flags to the lenders. You know, apart from legitimate corporate structural issues that you can argue, trying to push on these really sends up red flags to the lenders as to why are you asking this question? What are you trying to hide? Are there operations that you are concerned about that we need to know about? And it oftentimes does bring up issues that can be discussed, and you could minimize risks once the lender knows about them. Thank you.
Thanks, Eric. Thanks for that. The next question I have is, what trends do you see for future US sanctions? Tom, if I could ask you to take that question, please.
Sure. Yeah, it's a good question. The short answer is ask me in November. The longer answer is there. I mean, there are definitely some historical trends that I think will continue regardless of which party is in power next year. There's definitely been a trend since the end of the Cold War for fewer broad embargoes against jurisdictions and more targeted sanctions. You know, certainly under the Obama, Bush, and Clinton administrations, a lot of those were human rights focused and targeted on specific individuals in the Middle East, particularly. So I think that will continue. Under the current administration, there's a clear targeting of Chinese entities. Frankly, if you told me 3 years ago that the Hong Kong government would be subject to US sanctions, I would have found that hard to believe, but the world changes pretty quickly. So, again, I think it's a matter of a lot of very specific individuals and entities being targeted as opposed to broad sanctions. The big question really will be what happens with Iran. The U.S. is pushing to try and quote unquote snap back the Iran sanctions that were agreed with the Europeans and other entities who are now saying no because they want the U.S. to get back into the non-proliferation treaty. And I think that will depend on the outcome of the election next year. If the Democrats win, I think the U.S. will probably rejoin that treaty and sanctions on Iran will be eased. If the Republicans win, I think we'll continue to see increased focus on Iran. The other piece, I think, the other trend that's probably common regardless of the administration is a focus on the financial sector. I mean, it seems pretty clear that OFAC's main targets over the last 10 years plus are banks, and particularly foreign banks. I know HSBC, Standard Chartered, Deutsche Bank are all kind of in their crosshairs in certain respects. And so that's, I think, another area where the extraterritorial application of the sanctions will be most heavily focused on.
Thank you for that, Tom. And that concludes our session today. Just a thank you again to the presenters. Thank you everyone for joining us. And here's a reminder for some upcoming talks the next few weeks. Please do register with Trinity Talks if those are of interest. Thanks everyone again, and look forward to seeing you all next week. Thank you.